if I can.
No, later.
Thank you. Okay, sorry.
We're live.
All right. So I'll going through the reprint, which we're going off. It would have been the last one in the 430 email, HB 183 combined reprint. Starting bottom of page 3 of 16, which is still page 3 in the PDF. Just adding the public record does not include. The bill already was bringing in information submitted to the board. In this case, the Public Information Act Compliance Board. And then the amendment would also clarify the Public Access Ombudsman, who does a lot of work with the board. So just clarifying that information.
Does the ombudsman exist, or are we creating it?
That's an existing position.
Okay.
They submitted testimony on the bill, even there.
Okay.
They've been established for a little bit.
I saw them in the flesh.
Okay, I should have remembered
Virtually
that.
in the flesh.
Yeah,
That's okay.
virtually in the flesh. So then the next change would be there on page 4, starting at line 13. There was an annual reporting requirement for each custodian in the state, and that's been removed. That was part of the, I guess, concerns raised by the universities. They considered it to be a fairly onerous requirement to be doing this annual report by custodians. And then the next change from an amendment is page 7 of 16. And it's there at line 12. Currently in law, the Office of the Attorney General has to provide one staff member who is a licensed attorney to support the Compliance Board and Public Access Ombudsman's work. And then the bill originally would have increased that to 4. And then with the concerns brought by the AG's office, the sponsor, Delegate Learman, was willing to turn that to 2 staff members. So it would increase, it would be an additional staff member from the Attorney General's office supporting the board and the ombudsman on their work.
No questions? Next.
Okay. And then just a little bit further down that page, you look at 23. So one concern that had been brought up by the sponsor in their testimony was that there's no definition for unreasonable fee that custodians can charge for retrieving or responding to a PIA request. And so it's led to a lot of discrepancy agency to agency. Seemingly similar requests can get very different charges. And so the sponsor of the bill wanted to put a cap in that, but then the universities in particular, but I think some other agencies raised concerns that the agencies in particular universities in particular didn't have significant funding set aside and staffing set aside, so that they needed these fees in order to fund the work that they were doing. And so one of the amendments for most requests. So that would be, as amended, it would be $350. Did I hear a question?
Tyler, would that be for all the information they requested?
It would be a single request. That is something that I think the bill addresses, is the idea of, like 100 relatively small requests versus one request. I'm not sure.
I see Sarah's on the call. Sarah, can you tell us how much do these generally run?
The PIA requests?
Yes.
They vary a lot because the types of requests vary a lot. And to clarify, that wasn't saying that you can't charge any more than $350. That's the threshold that this is to be to invoke the ability of the compliance board to review it.
Okay, so that's not saying they can't charge.
No.
If they need like thousands of pages, they could
Yes.
charge more, but they have to
Yes.
get approval. I'm good with
Yes.
that.
It's sort of like a threshold of getting into court is a
And
better
Okay.
maybe
And it's not
analogy.
even get approval. It's just if
Mhm.
the requester feels that this $1,000 fee you have charged me is unreasonable, they can go to the board. But if the requester says, you know what, I've asked for all of this information and I think that's reasonable, then that's that.
Okay.
Okay. And then there is provision right under that page, so still page 7, amendment removing the opportunity for review or I guess jurisdiction for review for when an unreasonably failed to waive a fee. Then, sorry, there's a noise out there distracting. So there, line 24, unreasonably failed to waive a fee under 4206E of this title, that's being removed from this section. Page 8, again, removing a provision of, since the board won't be finding the removal, or board won't be finding unreasonably failing to remove a fee or waive a fee, since that provision will be removed. There's that, I guess, shifting the burden of when and how the fee would be considered unreasonable. Okay, and then
Okay, next.
the next amendment or next change from amendments is on page 10. And you'll see there that an existing law, when a custodian is sent information about a complaint, then their response has to be filed within 90 days. The bill originally would have made that 45 days, and then in work of compromising, since there's now 30 calendar days being specified for when the complainant receives the final determination of from the ombudsman is when they can file an appeal, is my understanding, appeal to the board.
What happens if they don't receive it within that time period? Do you know?
Sarah, my understanding is they would just lose the right to the appeal on that issue.
I think it would be sort of a jurisdictional thing. And the board, if it wasn't timely filed, then I'm not sure the board would be able to consider it.
Okay.
Mr. Chair, I just have a question. So Tyler,
Certainly.
you were on line 7 where it goes from 90 to 45 days. What is the difference there? Because I know we were just talking about 30 days, which is further down, but what was the 45 days?
That was the original drafted language of the bill, but the changes it to 30 calendar days.
Okay, it just seemed real drastic change in days. I was just concerned. Okay, thank you.
But again, this has been agreed to by the relevant parties, correct?
Yes, the sponsor's done a lot of work with pretty much every impacted party that I'm aware of, has gotten a chance to weigh in, and varying levels of support or sort of indifference to some of the changes coming in.
Okay, next amendment.
Then the next significant change, so coming again from page 11, that's still that crossed out language at the top, lines 4, 5, 6. That's coming from the same change with the changing in unreasonable fees and unreasonably failing to waive certain fees. And then it's also bringing in, my understanding from it is that there's concern of bringing in protected information coming into the board or to the ombudsman's office, I guess unnecessarily. So the board can't require a custodian to produce a public record to the board for review, but the board can request information about the public record in question from the custodian.
Chairman, may I clarify that just a little bit?
Please.
So that it actually just pertains to situations where a
In a
custodian
subcommittee meeting.
claims
Hi.
that
Yes,
Delegate
you did.
Lewis Young, we can hear you. You may want to mute yourself. Okay, not yet. Hold on one second. This can happen to any of us. We don't want people to hear our conversations. Not that we're doing anything wrong, but just to keep this.
Sarah, you're confirming when that provision applies?
sure. So it's when the custodian claims or says that the document is exempt under a specific section, which is 4301A22. And that requires a custodian to deny inspection when the record is protected by federal law. So basically that when that is the issue before the board cannot require a custodian to produce that document that is protected by federal law for inspection, but the board can ask questions about it. And that was really to address concerns. There is a provision that says that a custodian cannot be liable under Maryland law for producing a document and it would, just to clarify, it would all be confidential. It is also that the board can review and decide the dispute. It's not a situation where it would be disclosed outside of the board. But if a record is later found protected under, say, a Maryland statute, the custodian can't be liable for having produced it to the board for review. But there were concerns that the state of Maryland can't say, federal government, you can't prosecute a custodian for revealing a federally protected document that you were supposed to keep confidential. And so that is the concern addressed by that amendment. But if there are exemptions otherwise claimed, so say a custodian says we're not going to disclose this, it's a personnel record, the board could say we would like to inspect the record to make our decision, and so they could produce it to the board or something like that. And again, the board would be adopting regulations to make sure that any protected documents are secure, that they are not disclosed outside of that limited process, and that they would be properly destroyed or returned after the board process is over.
Okay, no further questions on that. We can go to the next amendment, next change.
Later in that page, line 20. So if a written response in this line of review going to the board, as we were just discussing, if a written response or other information that the board is requesting, so again, like trying to request information about certain public records, then if the request is not received now as the bill would have just said 30 days after the notice, then the request or after the notice for the request is sent, the board would decide the case on the facts that the board already has. And there's an amendment come in clarifying that it's 30 calendar days, which aligns with the previous section and which is provide that clarity for involved parties about the timeline that they'll be dealing with.
No questions? Next.
And then at the bottom of that page, they're starting lines 25, 26, requiring the board to issue a written decision within 30 calendar days after it's received the written responses or I would say lack of responses as well. And then again, page 12, requiring clarifying that the board's written decision will be within 30 calendar days.
Next.
Okay. And then I believe that's okay, down. It's not until the bottom of page 14, which is again removing another annual reporting requirement. This one was for the board and the ombudsman. And this is, so the amendment removes that annual reporting requirement. And then page 16, the final page of the bill, just bringing in section 3 is that clarifying language we mentioned before, that the bill is not intended to override any existing exemptions in Public Information Act. And finally, providing for the delayed effective date of this act. Are there any questions on those?
So the delay, I'm
Range
sorry, I don't have
section
any,
three.
reference, but, sorry.
Could you,
That-
someone please explain section 3 again? The amended,
So the section 3 is amended. It's there, technically line 8 of page 16 of the reprint. It just is stating clarification that when interpreting the bill or the statutes as they'll be affected by the bill, that there is no intent to change the exceptions and disclosure requirements that are already in Title IV, other than as explicitly explained here in the bill.
okay.
Is that where the legislative privilege section is, Tyler?
Yes, that's how it's addressed.
Thank you. And this delays it till July 1, 2020.
Okay.
So just a little extra time for this to come into effect, which
Great.
I imagine is just
Yes, that's good.
okay.
Are there any further questions from any of the members of the subcommittee? Okay. So,
The fiscal note then, I'm assuming is lower? Or it looks like the fiscal note was written on 2 positions and the bill said 4 and then was negotiated back to 2. Is that right?
that is correct, number-wise. Now, the fiscal note won't be revised until,
Right.
right?
Well, I think
assuming-
it's right now because there was some amendment to make it 4, but didn't it come back, Tyler, didn't it come back to 2 positions?
No, the 4 is the bill as drafted, so the fiscal note would have been written to that.
Oh, okay, so it could actually be less than what it is.
Mhm. That would be my
Okay.
guess. I don't know the exact threshold that's even with the amendments. You could put in a request or talk to the fiscal note office about if that's a concern about whether or not they could do a rewrite, but I know they typically,
Well, I think if it's under 100, the committee likes it. So if
Yeah.
it's half as many people, then it's half as much. It gets it down to
Actually-
75.
Actually, it's a third, isn't it? Because this would have added 3 from 1 to 4, and now from 1 to 2.
Okay, Erwin, be in touch and, I'll be in touch.
Sandy,
Chairman,
I'm
if
not
I
sure
may-
lawyers are good at math. I think it was
We-
4 and it went to 2.
We are already staffed by 2. So it actually, the bill would not add any staff.
Oh,
so-
okay.
so it's just a required one, but you were already providing
You
2.
were okay with it.
Yes.
That's
So
even
it's-
better.
It's a big fat 0.
All
Yeah.
right, Sandy, now you got your number for Shane. You got the bill down below, well below 100.
All righty. And
We have to pay
kudos.
the staff more because we're gonna ask them to do more now. Don't tell them that.
They
That's
can be
what
up-
add
questions?
technology.
Yeah, any further questions? Okay, so we had voted already to move forward with these amendments. Glad we had the opportunity to give, this helps me get prepared as well for, full committee and so on. So we are seeing no other hands raised virtually or otherwise. We are adjourned and we'll see you all on the floor.
Thank you, Tyler.